Hello. Sorry for inconvenience. I'm very sorry for the late. Hello. Am I audible?
Yes, ma'am, you're audible.
Yes, madam, you are audible.
Thank you, everyone. Thank you. Good morning. I'm Ajeenkya. I welcome you all for today's workshop. It is a great pleasure for me to introduce our speaker, Dr. D.Y.Patil Patil ma'am. She is Associate Professor of 18 years. She has completed
Madam, your
Yes.
internet connection is not
Yes, ma'am.
correct. Your voice is breaking, madam. Your voice is breaking.
Sorry, ma'am. Sorry, ma'am.
Yeah, you continue. I
Sorry,
don't
ma'am.
know. Yeah, maybe internet issue.
Sorry.
It's okay, ma'am.
I am
It's
Pooja
okay.
Devankar. I will. Uh, it is a pleasure for me to introduce our speaker, Dr. Dipti Patil ma'am. She is Associate Professor, Cummins College of Engineering. She has experience of 18 years. She has completed PhD in computer in 2014. She has filed 4 patents. She has published 84 papers. She has handled many research projects. She is a member of Board of Studies of Information Technology, SPPU. She is a member of IEEE and she is also live member of ISTE and CSI. She has received research grant of 11 lakhs from ISRO. I request Dipti ma'am to start the session.
Yes, thank you, Pooja, ma'am. I would like to first thank Ajeenkya University and School of Engineering for inviting me for this talk on IPR. Though Pooja ma'am has introduced me as, yes, I am an academician and also I am a patent attorney. So I am mainly interested in innovations, inventions, and the rights for those invention and innovations. And I always like to guide people for this type of legal things where students, faculty should be aware of their rights. So thank you so much for inviting me. Let me share my presentation. Hopefully I am audible.
Yes, ma'am, you are audible.
Yeah. Um, is my screen visible? The presentation is visible or like that?
Yes, ma'am.
It is visible, intellectual property rights.
Yes, ma'am.
Yeah, yes, thank you so much. So let's start. And before starting, ma'am, there are only faculty or students also have joined?
Only faculty is
Okay, only faculty is there. Yeah, okay. Uh, hello, hello.
yes, ma'am.
Yeah,
Only faculties, no students.
okay, no problem, no problem. So I would then talk in terms of faculty and in view of faculty. But most of the time we see that faculties are also students. They are learning something, and nowadays, as research has become very compulsory, then they are also they may be also a PhD student, so they may be a students also. So while doing all these things, while in this process of invention, these intellectual property rights are very much important. And as being a faculty, we know at least the background. I will just give you the gist and actual some facts you should know while when you are dealing with IPRs, that is intellectual property rights. So yes, what do you mean by intellectual property? It is a creation of your mind which has both moral and commercial value. Now, when you're talking about creation of your mind, your mind, your brain is thinking of something, and if it is new, if it is novel, and such type of novel idea or creation, if it has commercial value also, then we can call it as intellectual property. Now, why it requires commercial value? Yes, property matters. So, in traditional way, people used to invest their money by for buying the property. Why? Because they need the returns or the extra returns, which just keeping the money in bank will not help. Correct. So many people used to have property. So this property, we can say that we can divide them into two types, that is tangible or intangible type of property. Now, what is the tangible property? Tangible property is like which we can see, like house, land. We can show this is my house, this is my land, this is my car. So this type of property with to which we can touch, see, and show, that is like a tangible type of property, and which has a commercial value. And then the property which we cannot show, like you can nowadays people don't buy gold because there is a threat of thefts. So instead of that, people invest in e-gold. Okay, even people invest in shares or mutual funds or bonds. So these type of things, you don't know that you have invested in that, that is also your property, and it is also giving you some returns. So such kind of property which we can not see, but it is on paper, we can say that it is type of an intangible property. And one more intangible property of it is the intellectual property that we are going to discuss today. So I just said that it is a creation of mind, correct? So when you're with which we can have the different types of productions with the help of your intelligence, intellectual or creativity. And then we can divide this type of creation of mind into different types of IPs. So the IPs could be patents, it could be trademarks, it could be copyrights, it could be industrial designs, it could be trade secret, it could be geographical indications, and there is one more, that is layout design. So that we will discuss. And when we say IPR, sometimes people are not, people just say it is patent. So it is not the case. When you're saying intellectual property, these are the different types of the intellectual property. Yeah. So so IPR is all about the rights on these type of properties which we should have a legal title over this property. Yeah. So one the main the focus of many of us, engineering people, are having the focus on the technology, a product or a process or a material, and then we are more into patents, correct? So the one of the very first intellectual property is patents. So patents is related to the inventions of products or processes or materials. So for example, our mobile phone, we have mobile phone, and day by day, in a month or in 15 days, we are getting a new product of mobiles or the new models of mobile phones. And every time the technology is changing, and with whatever changes, whatever enhancement in the technology the developers are doing, all these things are already been patented. So that is nothing but the new novelty we are adding in the model, and we are coming with the new technology. So the patents are nothing but the technical solution to a technical problem. If we are providing it in a novel way, then yes, we can say it is our intellectual property, and you should gain a rights on that intellectual property, that is IPR. The next type of IP is industrial design. And what do you mean by that? There is also a design, there is a confusion of people that there is a design patent and there is a utility patent, or the product or a process patent. So when we are talking about design patent, we are talking about the aesthetics, the external features which are appealing to the eye, the new shape or a pattern or a configuration. So if you can see that when the mobile phones we used to use, we were having that flapping kind of mobile phone, correct? So that is one of the design, and that design also has needs a creativity. And then if it enhances the ease, or some industrial application is there, then you can have a design patent of the external features which has been introduced. So for example, you must have seen that we get the cars. There are various cars, and each car has a unique design, and that unique design also people have filed IPR rights of industrial design or design patent. So that is related to industrial designs. So, and when you're talking about product or process or a technology, then it comes under the product patent or a process patent that I talked about earlier. Now, the next type of IPR is trademarks. So you must have seen that whenever we go pass nearby to the highway, and we see that there is an arch of McDonald's, and we come to know that yes, there is a McDonald's nearby, and we change our route. So these trademarks are to attract people, to symbolize their business. So these trademarks are very important, and they show the identity of that company or a product or a brand. So Apple, that the cut apple is the brand. Also that brand is represented with the help of trademarks. Okay. So the trademarks are very important that in that way. So a visual symbol such as a word, it can be, you can see here, there are various there can be a simple name, there can be a design of like the McDonald arch, or a Google how it is written. The colors also matters. The Coca-Cola how it has been written, Mastercard how it has been written. So a visual symbol such as a word, name, or logo or label, or monogram or slogan can be trademark. And that trademark is important, that even you can say that if you have seen that initially there was a red cross sign of the for the doctors, correct, but now it is been changed to that snakes wala sign. So that is been changed. Why? Because already the Red Cross Society was having a trademark, or the that symbol was already been patented with the help of the IPR rights by the Red Cross, and hence the doctors have to change their symbol. So that is the actual value and the rights of the people when they are getting the legal title over on this all type of creation of mind. So that is the and everything you can think see it is of the industrial application is important. So everything we are thinking about in the way of commercialization. Commercialization is very important. We are taking certain things and we are not utilizing it, we are not getting returns, then it is a dead property. So the property should give you the good returns. So that's why these IPs are very important. The next type of intellectual property, and very important in terms of teachers, that is copyrights. So any artistic, literary or musical or dramatic creations, any proprietary rights are can be copyrighted. Now, being teacher, even as I have designed or I have developed this PPT, so this is my creation of mine. So I should take a copyright over this PPT. No one should use this PPT without my public permission. So that is the right which we get when we copyright this. But nowadays people take legally the copyrights, but actual thing is whenever any type of such work comes into existence, it is the IPR is created. What do you mean by that? Like you must have heard about the poems of the great Bahinabai Chaudhary. She has not registered any copyright, but still her poems are displayed or portrayed as her poems only. So actually, this type of, if I draw one drawing, it becomes a copyright of me. I don't have to actually register it legally, but it is once it is created, it is been granted to me. But if you want that I should have some written thing with me so that I can claim and I can stop other to use my particular art, work, then I should legally register it. That's why nowadays people are going for registering the copyrights. Okay, but actually it is not required, but it comes into existence as soon as the work is created. So the this computer program which you are writing, the paper, the research paper you are publishing, that's why you transfer your copyrights to the publisher, and that's why you sign the copyright agreement telling that yes, whatever copyrights I have on this particular article which I have written, I am transferring it to the publisher. Okay, so that is needed actually. That's why copyright agreement is important for the publisher side. So you are transferring your rights actually. So even that thing is there. Even if you draw a small diagram, that also you can copyright. So copyrights for academician, it is very important. You create one any project report, or you write any article, you write any poem, or you write create one PPT, or any program you write, software program you write, that you can copyright. Then comes geographical indications. Now, what do you mean by geographical indications? There is a place which has been the symbolization of any place. So identity of any place can be with a particular thing. Like we can say, when you say Assam, we always remember a tea. When you say Tirupati Balaji, we always see the Tirupati laddus. So these Tirupati laddus are there. When we say that Kashmir, we can say Pashmina shawl. When you say Bangalore or Mysore, we can say Mysore silk sari. So all these things are speciality of that place. And that is also the creativity of the people of that geographical area. So that creativity should be copyrighted, should have a legal title, and then that's why you have to take certain IPR over it, and that is nothing but the geographical indications. So the geographical indication, like when we say Ratnagiri, Hapus Amba, okay, so that is the thing. Identifies, which means what? Identifies agricultural, natural, or manufactured goods originating from a definite territory in India. Okay, so which possesses so Kolhapuri chappal, it is a geographical indication. So this, like, possessing special quality or reputation based upon unique characteristic of the geographical location, we call it as geographical indications, and that has also the rights. You cannot say Hapus Amba is from Assam. Okay, that is the, now it is the symbolization is with the Ratnagiri itself. So that's why you can say, you can see what type of geographical indications are there. You can see here that is Kashmir Pashmina shawl is there, chicankari work is from Lucknow. You can say there is Mysore silk sari, or the Tirupati laddus are there. All these things are the geographical indications. Okay. The next type of IP is the trade secret. Now I said that patent. What I said is patent is the invention. Patent is an invention. It has a technical. It can be a technical process or a product. Now, in patent, what happens is, whatever, when you do any invention, you have to disclose that invention when you are filing for a patent. So you are telling how to implement or how to reach to that invention. The whole method is been displayed or disclosed. So why it is so? So that there should be a policy that you, if you share your invention, then only people can use it. But if you will not disclose your invention, no one can use it. So now the trade secret and patents are there like complements to each other, where trade secret says that I'm not going to disclose my secret formula to others. Now, if you can see that in you go to McDonald's or some KFC, you go, and then the taste of the food we cannot match it at the home. Why it is so? Because the masalas which they use, they have kept them as a trade secret, and because of that the taste may not match. Even the Coca-Cola drink which we are drinking nowadays, and the Coca-Cola days drink which was available far back in this glass bottle, the taste was different. We may not have tasted, but the ancestors or our parents may have tasted this drink, and it was having a very different taste, and people were loving it. But the formula of making this drink was kept a trade secret, and because of that, later it was the formula didn't get available to anyone, and no one could make a drink like this Coca Cola. And this is an example of a trade secret. The trade secret is like it is not known to others, though and as it is unique, that's why we say that it is economically valuable and reasonable to mainly maintain secrecy. Okay, so that's why you can see now that we have seen how patent works and how trade secret works. So this one bottle has many IPs. I'm sorry, has many IPs. I have said that this bottle, the drink has a trade secret formula. Then the unique design of this bottle is being patented under the design patent. Then you can see the Coca-Cola as a trademark. Then you can see the packaging art are copyrighted. So you can see a single product may have multiple IPs, and each will give you certain results, and these are like 4 properties in a single product. And then you have to encash all these IPs in terms of returns. How we are going to discuss about it? Even if you can see here the mobile phone, you can see that you may have a trademark of, let's say, Nokia, the product, or startup tone. The startup tone of Apple was different, this Nokia was different, and it was like a trademark of that particular company. Even patents, the way it has been data processing method or operating system or operation of user interface can be patented. Even the code which is software which has been written can be copyrighted. The secrets, some of the things are kept secrets and not made open for maintaining the competitions in the market. And then you can have a trade secrets in a single design, or even how it has been looked like. The design of a mobile is can be can have a design patent. So a single product can have multiple IPs. Okay. Then I said that this type, one more IP is there, that is called as layout designs of semiconductor integrated circuits. May be useful for electronics people, where they design or the design the PCBs. And nowadays you must have observed that the size of the mobile phone has become very sleek, and it is not very heavy. So how it is getting possible? Because there is a revolution in VLSI technology or such kind of PCB design. So if you are coming with a different or new layout design which is adding the invention, adding the functionality or enhancing the usability, then you can have a layout designs on these semiconductors ICs. Okay, so chips are getting smaller and smaller. So this is one type of IP you can register with the help of layout design IP. Okay. So but this like it has a small span of 10 years, because you know that once the technology is emerging, you get a different new products with the new designs. Okay, so accordingly the usability in the industry, the you can just file, or the you can just register this layout design of semiconductor ICs. So this is also one of the IP type of IPs. Okay. Now I have, you can see, you observe here that I have written here as a protection for 10 years. Now, what do you mean that is, when I'm saying that I have a legal title over this IP, then you must have heard about the generic medicines, correct? And nowadays, the medicines which are available, there are two types. One is the proper pharma company, they are producing certain medicines, and for the same diseases, the equivalent medicine is available in generic medicines. Now, and they are cheaper than the patents. They are cheaper than the patents, correct? So, why it is so? Because uh, when we are saying that pharma companies come up with different formulas and then come up with the solution of medicines, and that they are selling in the market with their prices. Now, when you are producing them, you need to have the permission from the inventors or the patentees, and then you have to pay certain royalty and some everything. And in that case, the price of a product get increased. But how much time the people should enjoy these benefits? So there should be certain limits, so that common people will get benefited from these inventions. So that's why a specific period is allotted to each of the IPs, that the whatever rights they are going to get on their invention are for the particular period only. So for the, let's say, patent, it has a maximum protection for 20 years from the date of filing. From the date of filing, please, that is important. So that's why the validity period is important. So, and after 2 years of grant, every year you have to pay certain maintenance fee for the patents, okay, to the government, obviously. The trademarks are also yeah, the trademark which is there, it gets a maximum protection of lifelong. Yeah, the trademark is trademark, but every 10 years the company has to renew that. They have to pay certain fees for renewing that trademark, but you can keep it for a lifelong. Whereas patent, it has a fixed time period, 20 years. The third type of is design patent, where it has a maximum protection of 15 years, and after every 10 years, after 10 years, again for next 5 years, you have to pay the renewal fee. Copyright, I said, as it is as it comes into existence, it becomes available to everyone. Okay, so maximum protection 60 years, or even after the death of an author also, it remains with the author. It depends on the territory to territory. So you don't have to renew anything. The music of R.D. Burman will remains with the R.D. Burman's name only. No one can copy it, or it has to take a copyrights from the company or the author. Okay, so that is the copyright thing. And geographical indication also remains for lifelong, but after 10 years, every time the renewal fees has to be paid. Now, I said that faculty should be aware about this IPR. Why? Because unknowingly they are coming with the new ideas, novel ideas, which are very which has a lot of industrial applications, has a commercial value, but they are unaware of it. And there are certain rules, and if you are not following it, you cannot go for the intellectual or the filing a IP. Correct. So that's why it is very important to know about that what to do and what not to do before filing for IPR. Okay. So that's why academicians, researchers, entrepreneurs or industry people should take care of the rules or the laws. They should know about the laws about this IPR. So there is a IP patent laws are there. Like our law, the law, Indian patent law is there. You have the whole manual, and there is all the laws are been written. So when I said I am a patent attorney, like I am patent lawyer, so I know all the laws, and I have to see that when a particular person is coming to file an IP, okay, to register an IP, whether it is fulfilling all the conditions of the specified law. Okay, and why I'm telling you this is mostly I am going to talk about the patents today. So the patents are related to invention or innovation, and when it is coming into public domain, it is not patentable. So that's why people have to take care that when you are doing your PhD research and coming across something new, when you are publishing something, paper publication you are doing, then no one should copy your work, or no one should come up with the product with the help of only a product paper. You should get a proper citations for it. The projects which the students are developing, they are always having certain innovative ideas, and even study material which you are creating for students, and you are putting your videos on YouTube, they are under copyrights. So you have to think in that manner that whether when you are creating any PPT, whether you are using another's work, and if you are citing it or not, whether it is you are just plagiarizing it or not. All these things comes under the legal rights and laws, IPR laws, which you should be aware of. Assignments, even competitions, I am going to show you that how you can go for patents, and which things you can patent, or which you things you cannot patent, and if you want to go for patenting, how you are going to test the conditions that yes, my invention is eligible for the patenting thing. So the competitions and startups I will come later to this. So many I'm talking about invention, invention, innovation. So is there any difference between invention or innovation? So yes, invention is something different than innovation. How? Because invention is like something which you are a creativity of a product or a process, or introduction of a process for the first time. Now, if I am coming with the particular device of like just have a mirror of something like showing all the points, or the all the lines on your face, then that type of machine or that type of technology may not be there and introduced first time. So that is, I can say it is an invention. And then if I am making a modification to it to become more clear, you are enhancing the significance. So innovation occurs if someone improves or makes a significant contribution to an existing product, process or service. So a simple example is like you have this. So taxi is there. So initially when taxi is first introduced, I can say it is an invention. And then the riding service like Ola or Uber, I can say the with the help of taxi, the concept of having this the service, riding service, sharing ride sharing service of Ola Uber can be a innovation. So always innovation flows from invention. Correct? Am I audible? Any problem?
Yes, ma'am, you are audible.
Yeah. Okay.
No problem.
Thank you. Okay. So innovation always flows from invention. Correct. So why I'm telling you this is invention, when you want to patent a thing, it should be it is a novelty is very important. So if you are coming with the novel modification, then that innovation is patentable. But invention which has been introduced first time and has commercial values, it is always patentable. Means invention which is always patentable, but innovation is not always patentable. Okay, so if you can see this, this is a three-wheeled car. Okay, vehicle powered by a gas engine. This was the first patent in automobile industry that was filed by Carl Benz. And now the evolution of this, so I can say this is the first time introduction of automobile car which was working on the gas engine, and then it came with the innovation is this car. Okay, this is Mercedes. Okay, so you can see that how evolution takes place. But here you can say, I can say this is an invention and this has been an innovation. Okay, so both are very important. As first time something is been introduced, it is required. Otherwise, people are not knowing about it. And then making a modification is also important because we are not going to use this three-wheeled gas engine nowadays. Okay, we are preferring more and more better versions of automobile. So that's why the invention and innovations are complementary to each other. You can see another example, like you have this Wright brothers came up with the this type of design of a aeroplane. Okay, and they have patented it, though there was some another Indian person who has come up with it, but as he has not patented it, then the credit went to whom? This Wright brothers. So that is the importance of patents, that even if you come up with some invention and you disclose it to someone and someone patented it before you, then the rights goes to that person and not you. Correct. So that should not happen with you, and that's what I was telling you about the competitions. When the students take participation in competitions, they always have some certain innovative ideas, and they disclose it in the public. Okay, so if it has a potential of patent, I would always suggest that first go for patenting it and then disclose it to the public. Okay, so otherwise people will just copy you, take an idea from you, and they will patent it. So you should be really careful about disclosing your invention. So this is the also one of the examples that how it was initially when it was proposed, and nowadays what a technology we can see in this area of airplanes. Correct. Now, what I'm talking about, what is patent, what is patent. So, what is patent and what are the different liabilities, or what are the different benefits we can enjoy with this patent? So, exclusive rights given to person for complete disclosure of the invention. So, I said that patent and trade secrets are both are complementary. That is, patent you have to disclose everything. On disclosing you are getting that rights. Exclusive rights given to person for complete disclosure of the invention. And it is like you are getting a grant for a product, process, or both. It can be a combination also. So I said that period of patent grant is 20 years from date of filing. So the date of filing, and they are territorial rights. Now what do you mean by territorial rights? It means that if you are filing a patent in India and you got a grant on it, the rights which you will get, you are going to enjoy it in India only. You cannot say the US person that don't use my product because it is already been patented. They can use your technology in other nations or other countries, but not in India. So that's why it is a territorial rights. Okay, and also it is a negative rights. Now what do you mean by negative rights? Negative means when you are saying that I have got a patent or a grant of a patent, the monopolistic rights are given to the owner, where the owner can exclude others to make use, sell, offer for sale. It can exclude to import the product or process, also produce the same product without consent. So monopolistic rights is owner has all these rights. So without his permission, no one can produce, no one can commercialize, no one can sell or use it. Okay, but in that territorial area only. Okay, so that's why we call patents as the negative rights. Correct. So why should I disclose everything? So when I am going to disclose everything, people can use it. Obviously, people will copy it. How I will keep track of it? That is one of the case. It is there, but there are certain laws with which you can stop others to create or use your invention without your permission. The main philosophy behind this patent is that you should when whatever you are disclosing, whatever is your creation of mind should be valued. So it should get the owner should get certain incentives to individuals for new creations. So if I am not getting anything, why I am going to create the new thing or think out of box and telling others, you do like this, then you will get benefited. So others will get benefited, but the actual owner will not get anything. So that should not happen. That's why to get the owner should get incentives. These patent laws are there existing. Even you should get the recognition about your creation and invention. So that is there. Even so that is like a material reward for intellectual property. And the one more intention behind it is that people will say that no, why I will share it, I will keep it with me. So then just think about that. If that the automobile engine or the gas engine or the airplane technology, the people would not have disclosed, how we could enjoy that particular technology. They will remain in the like a Coca Cola only, it will just get vanish and no one can use it. So to motivate inventors to disclose their technology, which will make benefits to the industry, increase the commercial value, also the type of returns it will get for them also and for the countries. And that's why to make the available genuine product available to the public, this type of patent concept has came into picture. Okay, so that's why the patenting laws are there, where people are encouraged to disclose their technology and for which they will get incentives from the people who are going to use their technology. So these are some of the interesting patterns you can see. Now remember that there is a one the people are confused that I have just an idea and I cannot I don't have the actual working, but I know how it can be constructed and I have the whole design with me. And then if it is the case, the idea can also be patented in that case. It is not necessary that you will have a full-fledged commercial device with you, then only you can go for patenting. Even if you have certain ideas and that is implementable, that is feasible, and then you can say that yes, it can be patented and you can go for patenting it before implementing. Okay. Some of the products you can see that this is one of the Apple self-deploying screen protector, and this type of technology is not yet available in the market, but they have already patented it. Okay, so the this is like a actually this has a glass, a sensor is there which would deploy a cover when it sense the phone had fallen, or then it will get a protector for the screen. Okay, so with the help of this technology, the automatically deployment of screen protector will be done on the Apple iPhone, and this is a patent filed by the Apple. Even you can see, you can observe, is this a bee or no? Yeah, but it is not. It is a pollination drone actually. It is a Walmart's robotic bees. Okay, and they are used in agriculture purpose. And the proposed design includes camera that would allow the bees to identify crops and could then allow them to pollinate the same way real bees do. Okay, nowadays you get artificial honey also. Okay, so that you don't want to kill the bees, honeybees, and that's why people have come up with this different novel idea. So these are the certain kinds of interesting patterns people are coming with. And the being a faculty, you can motivate your students to think out of box and come up with some new ideas instead of just copying the work and just reproducing it. Always there is a scope to improvement. and that we always keep on telling to students. So that improvements, if you can patent and encash, commercialize, then being a faculty, being a college or a university or even a student can get help of it from it. So what can be patented? You can patent processes, machine, manufactures, compositions of matters or new uses of any of this. So the three conditions which should match when you want to patent anything. That is, it must be useful to the industry application. It should have an industry application. The invention must be novel. I said that it is novel, and that's why I said that whenever you are disclosing your idea in the competitions, the novelty is infringed, so novelty has gone. So novel means no one knows it, it has not come in a public domain. So even you, if you are giving certain seminar presentation also, then also if the idea is getting disclosed, actually then it is not patentable. So the usefulness in the industrial application is important, the novelty is important, and the third is non obviousness. Now you are saying that this is a car and it will go from one side to another. So this is obvious thing. What is new in that? Okay. So though it is something different way it is doing, uh, until and unless it increase the value in terms of usability or the commercial value, it is not increasing. You will say that it is a obvious thing. Okay. So the thing which you are proposing for patenting should be non-obvious. So these three things, the three conditions, if it is meeting, then only you can go for patenting the application, patenting the product or process. Now, why I am telling you this, and one more thing I wanted to say, when you are saying novel, now this mask you can, this is a mask which has been like in COVID days, there are different types of masks came into the market. You can see there are transparent masks, air filter masks, 3D printed masks. Now mask is not novel. Everyone knows about mask, but then whenever the first time the mask is introduced, that can be a patented thing. Okay, but then in that mask variations are introduced, and that modifications are also adding value to that particular design of a mask, and that is also patentable. You can see just this yellow things is like granted patent of no transparent mask. 2494 patents are being granted for the same product, but there are variations in that, and that can be proved with the help of these three things: novelty, usefulness, and non-obviousness. And then you can say that it is patentable and you can go for the patenting thing. So it is not the case, already it is there, what new in this? But think in the way that how it is new and useful. If you can prove that, yes, you can go for the patenting thing. Okay. So you can see here 1452 are already granted for air filter mask, and 418 are the in the process, similar to this thing. Now let's see how to go for patenting. What is the process of patenting? Now actually there is a patent office. Okay, there are actually patent offices, and they are based on the jurisdictory areas, and in those offices you can go file a patent or a patent application. There are certain forms prescribed. With that forms you have to fill it and provide the required information and file a patent application. So there are certain forms like form 1, form 2, form 3, like that, and those are the requirement for the filing of a patent. Once you file the patent application, with which I can say form 1 is the application of patent, form 2 is the complete specification, form 3 is statement of undertaking telling that I have not filed this type of invention in outside India. If I am going to, I will take a prior permission. Form 5 telling us a declaration as to inventorship, telling that we are the inventors. Now there is a concept of applicant and inventors. Okay. Now what do you mean by that? The applicants are the owner of the patent which will be granted, and inventors are the actual originators who have come up with this invention. Okay. So they are two different things. Applicants and inventors can be same. If they are different, then the declaration of the inventorship has to given that yes, we are the inventors and we are giving these rights to this applicant. that type of thing. Even if it is not the case, then also Form 5 has to be filled. And then you, when you do this, when you file this application with the complete specification, then the application, it gets published after 18 months of patent filing, patent application filing. Now, if you want that, I should not wait for 1.5 years for just publishing it, because until and unless it is published, it will not go under examination. And if it should not happen, then you can fill or pay extra fee, and you can request for the early publication. Okay. Once you do this, you once the patent application gets published. Now, what is the need of publication? That when you are disclosing it, it may happen that someone else has already come up with that idea and they must be using it, but they have not filed a patent. Now, if they come to know that someone has filed a patent on the same technology on which they are working, then they can take an objection and they can have a infringement case over the patentee, telling that this is already there and that's why this patent should not get granted. So that's why there is a motivation that the motive is to bring the patent in a public domain. One is like to let others know that this person has filed a patent on this technology, and if anyone is there who is already claiming it, the one thing. And second thing is that once it is coming in public domain, no one else can file a patent on it. Not now, I told you about the territorial rights, that in India, if I have filed patent, I will stop others to use it in India itself, but not in other country. But the reason behind publishing it in a public domain will stop others to file patent on the same technology in any other countries. So the person can produce it, but they cannot patent it in other countries. That's why the publication is important. Once it is done, the examination takes place. The examiners will report, the examination will generate the first examination report. You have to give the response to it if there are any queries or objections. If you can fulfill it, you may get a grant, or the controller will call you for the hearing to get the clarifications on his doubts. If you could clarify the doubts and prove on the novelty, you will get a grant of a patent. Otherwise, the application gets rejected. So, this is the process of the patent. So, when I am saying that you want to file a patent, the some of the tips or the advice I can give, that don't disclose your invention before you patent it. Keep the record of when you got that idea and how you have worked on it. Develop the idea and produce a model, at least a prototype. So I said that yes, you have everything on the paper, but at the time of hearing, they may ask you to show at least some prototype, not the commercialized product. But you have the time in your hand when you file a patent and when till it gets granted or till the hearing of the thing. So when you want to patent it, you have to ask following question to yourself: why your invention is needed? What the existing products are in the market like your new product, and what is unique about your product. If you can answer these questions and justify yourself, yes, you can go for the patenting thing. Now, how you will come to know that yes, I said that there can be infringement case and all. So now if you want to say that how I will come to know that whether anyone is there already coming with this technology. So that the first step of the filing of application is the doing a patent survey. Okay, so there are certain sites like Google Patents, Patent Scope or SpaceMate, with which you can get the information, or you can file the different patents filed all over the world. Okay, and then so see, when you're saying about patent search and you want to file now, you can't say that no, in India no one has done it. No, it is not the case. When you're saying a public domain, in all over the world, no one should have done it. So that's why you have to search or do a survey. Not only patents, the publications, the seminar report, the PPTs, anywhere the such type of technology should not exist. If it is the case, then only you can have a patent or you can file a patent or you should go for a patent. डालने के तो आप कभी भी patent application you can put, but if you are not very much sure about it, patent requires certain form fees, it has a drafting and everything, all these things are there and you have to pay the fees for it. So it has it can be a costly matter. So that's why you should, while before filing, you should take a proper patent search survey. Then I talked about the complete specification, that form 2 is very important, which describes the whole invention. So these are some of the parts like title, field of invention, background of the art, summary of invention, brief description of drawings are very important. That has to be numbered, and then when it is numbered, you have to describe them, the detailed description of drawings. And then in the in the patent document, one of the important thing on which you are going to get the rights are the claims. Okay, so claims should be properly framed. Okay, so that is very important. Even if a certain modification in words are done, the claims will get changed. So that's why the claims are very important. Then you have to provide abstract and drawings in the complete specification. Now, if you are not very sure about your drawings and you say, no, I have to work more, then what you can do, but this idea is novel, then what you can do is you can also go for the provisional application, where you will not provide the claims, but the other ideas you can disclose, and within a 1 year you can go for file a complete specification of the invention, and you will get the rights from the filing date of your provisional application. Okay, so that is like a priority date for you. So that is very important, and it will help you that how you can just say that no, I have filed a patent first, so I have the rights over it. Okay, so that is the thing. So I, whatever I said, it is this, like you have to describe the whole invention. Okay, the claims are very important. You have to if there is a biological type of material, this you have to deposit the things material in the Budapest treaty, under Budapest treaty, there in the lab. Then disclose the source and geographical origin of biological material if it is there, and abstract should be there, drawing should be there. The whole complete document is the complete specification. So this is the way how abstract is written, and there are laws for abstract writing the things also. So we can say the patent document is a techno-legal document. It is a techno-legal document, and it is not just writing the project report, but it has certain technical legal things to be included. So now in looking at the abstract, you will not understand. You will say, no, this is a simple abstract, but what font to be used, how many words in the abstract should be there, only those many words should be there, the limit on the words, these things 30, 25, these are the indications of citing the drawings. All these things are very important while drafting a patent. You can see these claims are there, you can say, and even this characterizing, comprises, consist of, it has a different meaning, and based on that only you are going to reserve your rights. So they are the claim should be carefully drafted. Okay, I have given this example. This is my patent, granted patent ka abstract and claims only, and I can say you tell you that initially people used to know that only mechanical people, electronic people can file the patent because they have the hardware, and in India software is not patentable. But nowadays people can go for, even computer people can go for patenting the processes, though algorithms are not patentable, but the process you can always go for patenting. Okay, sorry. So this is the way how the claims are being drafted. This is the way how drawings are drawn, where the boxes you don't have you have to number those boxes and then describe these drawings. You can see this is a patent grant certificate. Now here you can see that you can just see the patent number is given, application number is given, the date of filing. So I have got a grant of this patent from, and the rights from the 2011. So in earlier days, the patenting process was very, very slow. You can see that I had filed this patent in 2011 and I have got the grant in 2020. Okay, so that is really a pity that 9 years have already gone and people, the technology has got stale, and no, now people will say that this is already known. But actually, the concept was put in 2011. I can put an infringement case on them and everything, but it requires a very legal things and the investment and everything. But nowadays, you can see the next patent. This is also a granted patent, and you can see this has been granted filed in 2020, 10th April 2020, and the grant is got in the 1st December 2020. So within 9 months, the person has got the grant. Okay, so nowadays there is a process of expedited examination, and with that process you can get a grant within 1 year also. There are certain conditions on it, then only you can go for expedited examination. But yes, nowadays the patenting process has been the frequency is increased and the period is reduced. Okay, now you can see here the claims, how to form a claim. Now this is a device. Okay, this is a device, and you can say that this that is already there. So now the improvement you have to stress upon. So a game device having a handle, a throat portion and a head portion connected to the throat portion, wherein the improvement comprises a protrusion being secured to the handle. Okay, so the inventor is claiming only this handle, the handle design, or the introduction of this thing in the handle of the racket. Okay, so this is the way how the claim should be drafted, where the your contribution is to be claimed and not the whole product. Okay, so and that is possible. And so in mask also it was just what changes or what modification or what addition you have done in that mask is important. So I just explain this patent process. Again, I will just summarize it, that you have to conceptualize your invention, file an application. Either you can go for provisional specification or the complete specification. If you are going for provisional specification, you have to file the complete specification within 12 months after provisional specification filing. And if you don't do it, the application is abandoned, it has been discarded. If you go for complete specification filing, and if you go for early publication, then directly the patent will go under examination. Otherwise, you have to wait for 18 months. The publication after 18 months, you can go for, you have to file. Now here there is a one thing, that many of the people gets fooled by, I am not saying, but because of unawareness, sometimes it said, oh, it takes only 1600 rupees to file a patent. But that fee is for forming or the filing on form 1 only. But drafting it, filing it is one thing. Request for early publication, if you want early processing, is different thing. Then, for example, you take an admission in the students takes admission in the college. But do you take exam directly, or they have to fill exam forms also? So even if you take an admission in college, and until and unless you fill the examination form, the examination will not get conducted. Similarly, when you have filed a patent application, it is a need that you should also file a form 18 is there, to request for examination. Until and unless you file a request for examination, the patent application will stay just filed only. It no will the it is will not be get examined. So within 48 months you have to file the request for examination, and once you do this, then the examination, the patent assistant patent controllers or controllers are there who examines there are certain subject experts are there who examine this, take the patentability search and everything, and accordingly the first examination report is issued. Once the FER is issued, then you have to file the response for it. Whatever objections are given, you have to file the response, once it is been responded, the re-examination takes place. Controller, if it is not justifiable, controller offers a hearing of the patent applicant, hearing to the applicant, and application is to put in order within 12 months from the issue of okay. So if objections are not made within 12 months, it has been discarded. If it is made, the grant of patent is taken, and then there sorry, what is the time? 12:18. Okay. Then there is one thing called as post grant opposition and pre grant opposition also. So this is the process how the patenting takes place in India. You can just e-file the patent on this site ipindia.online.gov.in, or you can just post it to the patent office. Okay, but the e-filing fees are less than the filing it by the post. Okay, hard filing has the more fees. So maybe so who can file the patent? A true and first inventor, or his or her assignee, or a legal representative like patent attorney. Okay. And as I said that the patent of there are different offices are there. You have a Chennai office, Mumbai office, New Delhi office, and Kolkata office. And the jurisdictions are given like Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, and Union territories will file the patent application in Chennai. So the residence of applicant or domicile matters, or the applicant where he is working for business. Okay, that domicile, based on that domicile thing, you are going to select the corresponding patent office to file the patent. There are different types of patent. The ordinary patent application, as I explained. The convention application is like the patent application which is already been filed in other countries, and now you are designating India as the searching authority and you are filing it in India. So that is a convention application. And there is one type called as national phase application under PCT. That is, PCT is Patent Cooperation Treaty. Okay, now what do you mean by that? It is like see, I will suggest that no, if your patent has a potential, don't go just for filing a patent in India, but until and unless you have an international application, the value of patent will not increase. So when you want to file and go for international patent filing, you can either directly go to the specific countries and decide to file over there, or you can go through PCT application where it reserves the right in 142 countries. When you file a PCT application, okay, you can just file through PCT application, and again the search report will be carried out, or international search report is carried out, and then the priority date will remain the first date in which you have applied or the filed the patent, and from that day the whole survey takes place, and you get the 30 months period to decide that. Once you get a whole survey, you can decide that any things, any infringement cases, or anywhere the novelty is infringing. If it is not, then you can decide in which country I should go for filing. So it reserves your filing date. That's why PCT application is recommended. Okay. Now I also wanted to tell you that if I said that in 1 year also you can get a grant of patent, but then you have to file a expedited patent application. You have to pay the extra fees for it while requesting for examination. But there are certain eligibility criteria, then only you can file an expedited patent. When? Then if it is like the applicant has chosen India as international searching authority, it is a convention application, then the applicant is startup, or the applicant is small entity, or if you have one of the applicant as a female natural person, okay, some government institutes, okay, and some of the international applications like PCT, if you are filing, then you can go for expedited patent filing. Okay. You should also know that which are the things which are not patentable. Now, if you are, if your invention is saying, yes, I have designed a machine that is giving me 100% dust free, the washing machine is giving me 100% dust free clothes. So that is just a frivolous thing. It is not possible. So the such kind of frivolous thing cannot be patentable. The things which are the, if you are saying I'm coming with the invention of making the bomb, okay, so that is a disastrous things, okay, it is not good for human being. Even you can think of the coronavirus, people have come up with very creation of mind, they have created a virus, but it is not good for the humanity, correct? So such kind of things cannot be patentable, patented, okay. Just you are coming with some equation which is new, like Archimedes principle, so that type of thing is not, just equation cannot be patentable. But yes, if using that formula, if you are coming with certain new product or a process, then yes, that product and process can be patentable. uh, just you are taking two mixtures and just making a new thing, okay, the mere discovery of new form of a known substance like salt esters, you are taking a, just you know about salts and you are just making certain things and you are getting something new substance, but the properties are remaining same, then that thing cannot be patentable. Even let's say take an example that a substance you are just mixing, that is combining the things, ye hai, or everything is known, just I have joined it and coming with the new product, then it is not patentable. So like let's say paracetamol or brufen, you are just combined and given as a drug, so it is just two things, you are just combining it. But a mixture resulting into synergistic properties of mixture of ingredients like soap, detergents, then that can be patented. So that is the same thing. Mere arrangement or rearrangement or duplication of known devices are not patentable. Even method of agriculture or horticulture are not patentable. Um, the process of treating the animals or the human beings are not patentable, like removal of cancer tumor, removal of dental plaque, that is not patentable because it is useful for human being and that should be available to the public, and that's why it is not patentable, okay. But medical instruments can be patented, okay. Plants and animals ka species you can not patent. Then mathematical or business method or computer program per se or algorithms are not patentable, as I said. But if it is combined with the some hardware and you are coming with some process or a product, then computer people also can patent your process, okay. Literary and dramatic thing cannot be patentable, it can be copyrighted. Even just mental act of how to play a game cannot be patented. A presentation cannot be patented, it can be copyrighted. Topography of integrated circuit, it will come under layout of semiconductor design, is not patentable. The invention which in effect is traditional knowledge. Now this is related to some traditional known component like turmeric or neem kind of thing. So these are our traditional knowledge, okay. Though they are new things, but they are already available in our dictionaries, and hence they cannot be patented. So you can see that as I said that computer people can also patent. Now this is one of the patent you can see in cloud computing, in artificial intelligence, in automotive hacking. So many patents are been filed and is been granted. So this you can see how many patents are being granted for cloud technology or say artificial intelligence, for automotive hacking. So now so that myth is there. So just remove it that I cannot patent my thing because I am a computer person. No, it is not the case. But the way it has been presented, it has been portrayed is very important. Then you can obviously patent it. Now wanted to tell you about something like impingement thing, that I said that is a post grant opposition or pre grant opposition. Now what do you mean by that is like I just said that when the patent gets published, a patent application gets published, someone can come and file a pre grant opposition telling that this is already been known, I am already using it, that's why it is not patentable. Similarly, after grant of a patent also, the person or the other people can come and file a post-grant opposition telling that this should not be granted because this is already in a public domain. Okay, but that should be done within a 1 year after the grant of a patent. Okay, so that is possible. So you should have take care that yes, the whatever things or whatever invention you have applied for patent is unique, novel, and providing the non-obviousness thing. Okay, so the a patent can be challenged and revoked any time after the grant of patent on a petition also. Okay, so that is related to oppositions and revocation. Now how it is important, because you can say no that I have given some idea, presented some idea in competition. I have all the things. That's why I said that when don't disclose it, and whenever you have an idea, you just mention it that I have got this idea on this day and everything, so that if anyone else just take your idea and file a patent, you can prove, and that time you can go for pre-grant and post-grant opposition or a case of infringement, telling that this is my invention, I have presented to this person, and it has been copied. Okay, so that is the protections given to the patentee also and public also. You can see many industries file or sue each other for filing a patent or using their technology. Let's say GSK files a patent suit against Glenmark using their technology, and they are saying that we already have this granted patent, how they can use it. Okay, so that kind of cases can be filed, but mostly big industries go for this because it requires a lot of money. Infringement cases, it requires lawyer fees and everything. But yes, there is a law with which you can protect your patent. Okay. Now there is a concept called as compulsory licensing. Now once you get a patent, grant of patent, it is not, as I said that one of the condition is that patent should be should have an industrial application. So commercializing the thing is very important. Okay, so that's why this compulsory licensing came into picture, that if you don't commercialize within 3 years, you have to and anyone else is interested in commercializing it, you should give the rights license to that person. Yes, obviously you will get a royalty, but yes, compulsory licensing has to be provided. Okay, so that is the compulsory licensing thing. And the provision is for working, the patent should get commercialized. It should not be just a paper, it should give certain returns. The product should get available to the people in reasonable, at a reasonable price. You should then promotion and dissemination of technological invention is the one of the motive behind compulsory licensing, and protection of public health and nutrition is also one of the thing. Now there is a one renowned case of Natco and Bayer. This is the first case of compulsory licensing, where what was happened that Bayer Corp has filed a patent for the particular medicine for on a cancer. Okay, and it was very costly, around lakhs. Okay, and that's why the common people could not afford it. Then the Natco, who is the pharma company, file a case for the compulsory licensing, telling that we can reproduce it in a small amount or with the reasonable price. Then as it was not available to the public in with the appropriate price, then Natco wins the case, and then it has reproduced that medicine. Nexavar was the medicine, and then they have reproduced it, and then it was available within to the public with the rupees 8,000 only. So that is the case study which was there for the compulsory licensing case. Okay, so this is one thing. Even I was telling about this turmeric and neem. So initially the patent was granted in USPTO, like US Patent Office, on wound healing properties of turmeric. Just imagine that then how the turmeric will be costly in India. Even the European Patent Office has granted the antifungal properties of neem. That patent application was granted. And then our scientists like Dr. Raghunath Mashelkar, they took and other committee members filed this patent revocation case, while telling that this knowledge, this turmeric use or neem use is already known or public domain. This is our traditional knowledge, and it has been recorded in traditional knowledge digital library, TKDL. Okay, and then the case was filed, and then we won the case, and then these two patents got revoked. So this is the case of revoking the patents. Even if the patent gets granted, if there is a infringement case, then the patent also can be revoked. Okay, terminated. Now let's talk about certain government support policies. So nowadays, I just said that the patent fees are there for these forms, and it is a costly affair because yes, you a normal person can draft a patent, but converting it into techno-legal document, you may get an assistance like a power of patent attorney and like that, and then there is a consulting fees also there. Even form fees are there. So it takes certain cost also for filing a patent. So that's why government has given has come up with the various schemes under Startup India or Atmanirbhar Bharat. Okay, and that's why they are promoting that people should not just invent, but it should commercialize their product also. And that's why they are promoting to do startups. Even now, faculty can also start their own startup, being in a college role or job. Okay, so that is been now promoted. And when I just said that when you are just when you are a startup or a natural person or a female applicant, you can the fees of the government gets reduced. Even 80% of the fees government pays. If there is a power patent attorney fee and all the things are there, the government support policies are there, and you get the returns. Even after the grant of a patent, or even while filing, you get a facility where you get the reimbursement of the filing fees. Okay, so that are the government policies. You can see here now there was natural person, startup, small entity, and now even educational institutions are also treated as a natural entity, and the form fees are being reduced for them. Okay, the industry has 4 times more fees. Okay, whereas the you can see here 1600 rupees for form 1, and whereas for others it is 8000. Okay, so this is the how the difference between form fees are there. So that is been given by the government policies, where educational institutes and also getting the benefit of form fees. Even you can see NRDC, that is National Research Development Corporation. Now, under this NRDC also there are various other government departments. So, DPIIT is Department for Promotion of Industry and Internal Trade. So, these under DPIIT, if the startup is registered, then you are going to get 80% of the expenses, or sometimes 100% also from the government. Okay, and there are certain policy from central government, and even there are certain policies, government policies to for the patent filing and everything by Maharashtra government too. Okay, and there are certain departments like DST, DBT, MHRD, even Ministry of Labor and Employment, or MCA, and or Niti Aayog. You must have heard about it. They are supporting the startups and supporting the patents filing too. Okay, so do take the advantage of all these things which are available for you people. This is some of the process with which you can submit the application. Yes, it will go through scrutiny, and if it is really worth, then the fees get sanctioned and get reimbursed by the government. Okay, so this is the process for this Maharashtra State Innovation Society. Okay, under which also you can get the filing reimbursement. Obviously, either or from where you will get the reimbursement, not from both. So this is it. So do invent, do innovate, and do commercialize. Be entrepreneur, and then you yes, there are this IPs will give you the returns which you cannot imagine with your land and houses. Okay, so be billionaire with the IPs. All the best. Thank you.
Thank you, ma'am, for the interesting session.
Yeah, thank you.
Participants, do you have any questions? You can ask. I request
Uh,
participants.
Have they got bored
No,
or were
ma'am,
they at
not at all,
interesting?
ma'am. It was very interesting session.
Yes, thank you so much. अच्छा अनम्यूट करना है.
Yes, you can unmute your mic.
Am I audible?
Yes.
Okay. Hello, ma'am. This is Dr. Aishwarya.
Hi.
I have one question. If we want to patent any app design which is applicable for healthcare industries, so can we go for that? Because everybody can prepare the app, which is a very simple thing. But if we design something in such a way that it can help to some needy people and direct application in some detecting any disease or count any disease or something like that. So
Yeah.
can we go for any patent for that?
Yes, ma'am. As I said, yes, mere app cannot be patented, but obviously for healthcare, you must be taking certain inputs from some hardware. And if it is the case, if you have a combination of hardware and software, you can show it as a process or a product with the hardware. Okay, and yes, you can patent that thing. And if you can just claim on the novelty which you are introducing in that. So even if it is an app, but it is following certain process. Okay, and
Yes.
if that process is novel, well, and even if you are taking certain inputs from the certain hardware, even a speaker or a camera or a sensor will also do. Okay. So if it is the case involved in your process, yes, you can patent.
Okay. So, ma'am, another one question that if we are designing any diagnosis instrument for healthcare industries, so
Okay.
before patent, can do we need to perform any patient testing or any limitation for that?
No, no, not like that. Not required. You can do it because when you are going to get, do it commercializing it, then you have to test it. But otherwise, that product, if it has novelty and you can prove it with the process or the whatever are the evaluations, even the simulated results, it is okay. It is okay. No problem. No need to test on patients.
Okay, actually, sometimes if I like give example of a simple ECG machine also, if we are designing in a different way, so we need to record the ECG signal directly from the human being. So in that case, it
Even
will
if you
affect
can
the.
simulate it or you can take it already recorded signals, if you can just take as an input with the help of programming in your device, that is also okay.
Okay, so that much information is also enough for the patent process.
Yes, yes. You have to prove it, you have to justify it. The
Okay.
data which is coming from human being and the data, the frequency, if you can match with the simulated thing also, and you can the machine you can show or justify it, you can go for patenting, no problem.
Okay, ma'am. Thank you so much.
Yeah, welcome.
It is such an honor for us to have you today between us. I thank you, Dr. Dipti Patil ma'am, for taking time from your busy schedule. Thank you for enlightening words that inspired us all. I want to thank Chandrasekhar sir and Samir sir for technical help. Thank you, Biswajit sir, for supporting me. Thank,
Yeah.
thank you all the participants for attending the workshop. It was really an interesting and informative session. Looking forward to our next interaction soon.
Thank you, madam. Thank you for inviting me and giving me chance to share my knowledge. Thank you so much.
Thank you, ma'am.
Yes. Okay.
Thank you, ma'am.
Thank you.
Participants, you can leave now. पण आपण 1 वाजेपर्यंतच लिमिट दिली होती ना.